Hello, everyone, and welcome back. In my previous discussion, we talked about entities for real estate. And during that presentation, I went through a number of things. And from time to time, I discussed trusts. Now, I know there are a lot of people in the audience who are saying, so what type of trust should I have? And when should I have one trust versus another? Because I really didn't go into any detail. So I am really pleased to be able to present to you Michael Potter. Michael is an expert in this area. He is an estate planning attorney. And the reason why I'm so excited to have him give you an overview of trust is because Mike not only teaches, but he lives this stuff every day. So he's always up to date on the very best strategies for keeping you safe. So Mike, welcome.
Thank you. It's great to be here, and I'm glad to see everyone.
Mike, first question. Is there any trust that people should have just starting out? Is there a kind of trust that just about everybody should have?
You know, Wendy, looking at the 7 trusts we're going to talk about tonight, there are different ones for different kinds of situations, but certainly the one that everyone should have would be the revocable living trust. So within the context of entity planning, I know you're the expert in corporations and limited liability companies and even limited partnerships, but the first one everyone should have would be the revocable living trust. Now, this is a trust, Wendy, that the reason it applies to everyone is because there's a 100% chance we're all going to leave the planet one day. And so with the revocable living trust, you're able to completely escape the need for conservatorship while you're alive if you become disabled, and you're also able to completely avoid probate, which typically can take from anywhere from 6 to 14% of the estate and take a year or two to complete, and it's a public proceeding. Whereas with the living trust, whatever assets that you have moved in there by the date of death, then those assets completely escape probate.
Okay, so you're saying that if you don't do this, whoever's looking after your estate, if they loved you before you died, certainly isn't going to love you by the time he's finished.
That's right. They're going to consider the case a big pain in the rear.
Okay, so everybody who is, even if they're just starting out in business, really should have a fundamental revocable living trust.
That's true. It's actually the best time to establish it before you have a lot of assets, because that way you can get things set up. It's so much easier to fund it in the early stages and get it going, so that as you acquire assets and as you acquire other types of entities, the living trust can work with those as part of an integrated plan.
Okay, so let's say that our real estate investor has a couple of LLCs, has some properties, has them owned by his revocable living trust because he's just starting out and he's got everything going, and he progresses a little bit. What's his next step? What should he be looking at next?
Well, there's a couple of ways to go. If he wants to engage in asset protection, one of the things he might consider is the use of a wealth preservation trust in conjunction with a limited partnership or limited liability company or corporation. Both the living trust and the wealth preservation trust under the Internal Revenue Code are considered grantor trusts for tax purposes, but the wealth preservation trust that we're talking about now is actually outside of your taxable estate and beyond the reach of creditors.
That sounds like that's a really good thing to have in your back pocket, especially if you have children who are disadvantaged, might outlive you. You want to make sure that they're looked after, in addition to giving you basic asset protection.
Right, and not only does it help protect you, Wendy, but it also helps your kids in case, for example, your son or your daughter hasn't yet met their future ex-spouse. You want to protect them from divorce, and you also want to protect the inheritance that they receive from you, even if it's a great big life insurance policy owned by this trust. and maybe a couple of LLCs that contain your rental properties or the properties that you're flipping and so forth. You want that protected so that not only do you not lose it to predators through lawsuits
Right.
or through divorce, but neither do your kids. And I know for most of us who are parents, we're really concerned about preserving and protecting what we've worked so hard for and what we want to pass down to our children.
Great. So that actually brings up a really good point, because as the career of the real estate investor progresses, his family is also growing up at that point. And so by the time he may have, a fair amount of wealth to consider, he may have grandchildren or other adults or even charities that he wants to look after. So what's kind of the next step from here?
Well, of course, you want to keep assets protected beyond the reach of creditors. And the two trusts in this discussion that we're going to talk about that really do that are the Wealth Preservation Trust and also the Multiple Generation Dynasty Trust. Now, what's different about this and what's similar, first of all, about the Wealth Preservation Trust and the Dynasty Trust, they are both outside of your taxable estate. So they're not going to be hit with estate taxes, and they're impervious. If you set them up properly while your legal seas are still calm, you will have protection from divorce and from lawsuits, and so will your heirs.
Okay, that sounds really great. Now, I know that sometimes when people look at irrevocable trusts, they get a little nervous because it's, a control thing. But it
Right.
really, sorry.
Right.
So it really comes down to, you got to pick your partners well, you got to pick your trustees well, and that will give you the best protection.
That is correct. And one of the things that I like about the Dynasty Trust is that you can build incentives in there so that your children, or if you don't have kids, maybe your nieces and nephews or whoever you choose as beneficiaries, you can build incentives in there so that they are motivated to be achievers instead of takers. In other words, you can motivate them to become entrepreneurs, real estate investors, to do community service and help make the world a better place. You can put incentives in the Dynasty Trust so that they get rewarded for being productive members of society.
That sounds like a great idea, and I'm sure that most of our audience doesn't really think in those terms, so this is going to give them really something to think about. Okay, so
That's
now
right.
let's move on to the limited partnerships. Where does that fit in?
The limited partnership is a planning and asset protection device that's been adopted in all 50 states. However, just a few years ago, Nevada started as the first state to adopt what's called the triple LP, or limited liability limited partnership. I actually participated in getting that law adopted. Now, since it was first adopted here in Nevada, it is slowly beginning to spread to other states. Just a handful so far, but the limited liability limited partnership, or triple LP, is the more advanced version of the limited partnership that most people are used to. What's different about it is that the general partner enjoys the same liability protection that the limited partners traditionally enjoy, and in Nevada, we have what's called the sole remedy statute, so that even if hell freezes over and a lawsuit creditor somehow wins a lawsuit against the partnership, he's going to have to wait a very long time before he gets anything, and the best he can get in most chances are the what's called through the sole remedy statute a charging order. And done correctly, the charging order will force that creditor to have to pay taxes on money they can't collect. And they hate that. So typically, what I would recommend is that a good real estate investor uses the LLC and the corporations, as you have talked about, and then have those C corporations and LLCs owned by the limited liability limited partnership. And then the two partners of that partnership would be your living trust and either your wealth preservation trust or your multi-generation dynasty trust. So working alongside of the living trust as one of the limited partners, either the wealth preservation trust or the dynasty trust, either one can be the other partner. And that gives you not only tax advantages, privacy, lawsuit protection, divorce protection, but a great way to preserve the assets not only for yourself, but for the generations that follow you.
That's a great tool. Now, a lot
It's
of
a
our
great tool.
people in the audience I know are going to be using their IRAs to do real estate investing, and so they really are going to be growing their wealth inside of those IRAs. And
That's true.
so they're going to want to pass those down. And what's the best
Yep.
way to do that?
Well, the retirement inheritance trust is a relatively recent phenomena in the law. It's only been around since, about 10 years ago. But the IRS issued a very significant private letter ruling about these a few years ago that really gave us some insight on how they would treat it. And as you know, most people, when they inherit an IRA, they cash it in and they go spend the money.
Yep.
What the retirement inheritance trust does, Wendy, is it allows the heir who receives that to be protected from their own bad spending habits and from their own divorces and their own lawsuits.
Yep.
The trust, when it is set up, would be the beneficiary of your IRA, your 401k, or other retirement plan.
Okay.
So let's say that upon the passing of a spouse, it could then go into this trust. We would set it up before the spouse ever passes, or if you have a client who is already a widower or a widow, this trust would be the beneficiary of the IRA or other retirement plan. Now, it would be a revocable trust, and it can be changed at any time up until the IRA account owner dies. At that moment, it becomes irrevocable, and then the assets inside of it cannot be reached by the creditors of the beneficiaries. So let me give you just a quick example of how this might be used.
Okay.
I've seen it used where an IRA account owner or 401k account owner would have their children, their adult children as beneficiaries. But an even more powerful way to use it is to leave your life insurance to your kids tax-free and then use the retirement inheritance trust with your grandchildren as beneficiaries as just one example. Let me say why that would be so powerful. You might have adult children in their 30s and 40s, but have grandchildren who are, say, 3, 5, 6, 7, 10 years old. If you had a granddaughter who's 3 today, and she were to inherit through the retirement inheritance trust your IRA or 401k, she's got another 83 years of life expectancy. And this trust would pay her out the minimum required distribution that the IRS has. Let's call it 4% for discussion purposes. But let's say that the IRA continues to grow at, say, 10 to 12%. That means it'll double in 6 or 7 years. And if the investors are using their self-directed IRA to buy real estate, it probably will double even faster. So let's say that they start taking out some of the proceeds of their profits from their IRA, but at their sudden death of a heart attack when they win the lottery, it passes so that the grandchild, the granddaughter who's 3, now becomes the beneficiary for real. Now, she's got 83 years ahead of her, and if this fund continues to go and grow and is managed wisely by the trustee that the client selects, then over that grandchild's lifetime of the next 83 years, even a modest IRA could very well grow into millions of dollars in a very tax-advantaged way, in a way that protects her from her future ex-husband and protects her from lawsuits and creditors for the rest of her life.
That's brilliant.
It is wonderful.
Mike, there are a lot of people in the audience I know who are concerned about privacy. You and I have talked about this a lot because there are lots of people saying different things about how you can be private, and of course the states are making it more and more difficult in filings to stay private, a lot because the U.S. is getting quite a black eye for the fact that it doesn't collect enough information. And this is probably going to result in even the states that are private now becoming more and more transparent. So what's a good alternative for people who have privacy as an issue?
Well, as you know, Wendy, if you have a corporation, you cannot have any other entity serve as an officer. It must be a human being. However, that's not the case with either limited partnerships or limited liability companies. So with an LLC, for example, or a limited partnership, we could use a privacy management trust as the manager, and that name would be posted on the public record. So let's say, for example, that we created for a client a privacy management trust called the Lake Tahoe Trust, just as an example.
Okay.
And the Lake Tahoe Trust would be listed on the annual filing of officers and directors, not of the corporation, but managers of the LLC or general partner of the limited partnership. And as you know, that's a once-a-year requirement to post that with the Secretary of State, so they know who to contact if there's a problem and so forth. Well, we could post the Lake Tahoe Trust as the manager of ABC Limited Liability Company, for example, and that is what would appear on the public record. Now, we would typically provide an administrative trustee who would sign the record, but it would not be the client. The client would be the great and powerful Oz behind the curtain, signing only as a management trustee. So the management trustee is not disclosed to the general public. The management trustee is not listed on the Secretary of State form that's filed every year. Only the administrative trustee, and that is their sole duty. The management trustee, which is the client, never appears on the public record and controls everything from behind the scenes. And that way they could manage the LLC or the limited partnership and have full and complete privacy by using the Privacy Management Trust.
Okay, great. Last trust. A lot of people, as they gain wealth, start thinking about their favorite charities and are wondering, how they go about doing this. Some of them think, well, I have to form my own charity in order to do any kind of charitable giving. What kind of alternative do they have with trusts?
Well, I like to talk about this trust because it's one of my favorites. I have drafted hundreds of these over the last 25 years. And I had a couple who attended a workshop with me in San Diego. The husband was a retired naval officer. The wife was a recently retired school teacher. And they just wanted to sell their home. Their kids were grown. They wanted to travel the world and go see stuff, drive around in their RV. But they owned some stock in Disney that they bought back in the 1950s when Disney first went public. And their $3,500 investment had turned into $1.8 million.
Whoa.
nice capital gain.
Mhm.
Now, at that time, if they had paid the capital gains tax, they would have paid about 28% to the Clinton administration, and they would have paid another 10% in California to the state of California for its capital gains tax. So about 38% of that would have gone away in taxes to some tax collector's checkbook. Well, today, the federal capital gains tax is 20%, so a little bit less, but still significant, larger than it was under the Bush administration. And it's 20% federal, and then whatever the state capital gains tax is.
Right.
By using the capital gains bypass trust or charitable remainder trust, as it's referred to in the Internal Revenue Code, you can completely avoid all capital gains taxes on the investment that you put in there. And what's nice about it is when the trust is functioning, then you have the ability to be the income beneficiary for the rest of your life. And then upon your eventual death, that can pass to the charity of your choice. Now, in my case, that would be the Boy Scouts and the Red Cross and the Make-A-Wish Foundation. But in other people's case, it might be their own family foundation. Think about that. You can have the life insurance go to your kids. You can have the capital gains completely avoided. Let the capital gains bypass trust pay you an income for the rest of your life, and then it passes to your family foundation at death while your grandchildren inherit your IRA retirement inheritance trust for the rest of their lives. And guess how much the federal government would get from that? Nada.
Donut hole.
And the nice part about it, it's right in the code. This is nothing that is secretive. It's nothing that violates the law. It's not tax evasion. It's right in the code, and the IRS approves these all the time.
That's great. Well, Mike, I think you've given our audience a lot to think about, and hopefully some things that they've jotted down that they're going to want to investigate further, because there are some absolutely wonderful strategies in here for real estate investors starting out and for those who are a little farther along the path. I want to thank you for your time. I really appreciate it, and wish everybody else a really good rest of your seminar.
Thanks so much, and I'm proud to be here with you. Thanks again, Wendy.
Bye-bye.